Something very important to know about discrimination claims is that you have 300 days from the date of the adverse action to make a charge of discrimination, either with the EEOC, Equal Employment Opportunity Commission, or the IDHR, the Illinois Department of Human Rights. So a little bit about taking a charge through the administrative process. So let's say you've made a charge, and let's say it's for sex discrimination. You've made your sex discrimination charge and you have submitted it to the IDHR. What happens next? So they will assign it to an investigator. And at that point, you have an opportunity within the first 30 days to opt out of an investigation and get your notice of closure and go immediately to court. This is a tactic that we use as attorneys very often to motivate employers to settle. While the claim is sitting in the IDHR, and if you allow it to sit there, there will be an investigation, and there will usually be a phone interview between you and the investigator, and a phone interview with the employer as well. The parties also can decide that they want to mediate the dispute in either agency. And so sometimes that's a great free option to try to mediate it at that point. In both agencies, the IDHR and the EEOC, you need a pass-go card. In the IDHR, that is called your notice of closure, and in the EEOC, that's called your notice of right to sue. You need to have these papers before you can file suit, either in federal or circuit court, because they want to make sure they're weeding out the people who really aren't serious about their claims. From the time that you get your either notice of closure or your right to sue, you have 90 days to actually file a complaint in state or federal court. This is non-negotiable. You have 90 days. And so certainly if you're up against that, I would use an online date calculator, because they do not mess around about these 90 days. It is something very, very important. A sex discrimination case that I worked on, I found to be particularly interesting. It was the case of a medical device saleswoman who was really killing it at her job. She was amongst the top in her company, and she had high ranking for her territory. But when she informed the company that she got pregnant, they started going on ride-alongs with her to hospitals. They said things like, "You're going to want to take it easy after the baby." They even offered her a demotion, and they wanted her to give all of her clients to a man. Luckily, we were able to resolve the situation, but I'll never forget the testimony of what her supervisor said. "You're going to want to take it easy after the baby. You'll want to be at home, so you should accept this demotion." And my client was very strong and not about to do that. She knew what her skills were, and she wanted to pursue a career in sales. She wasn't going to let that stop her. Retaliation under the Illinois Human Rights Act and under Title VII really means an act of retaliation for doing something that's protected. So the protected speech of saying, "Hey, I'm a person of color and this is happening to me. I'm facing some discrimination." And then let's say the employer terminating them in short order, that would be retaliation. So it really is complaints about discrimination within those buckets that we call protected classes, and then a retaliatory act. It doesn't just have to be termination. It could be moving to a different department that really isn't your expertise or your area. It could be putting you on an unpaid leave of absence. Right now, we're working on a case where the county put our client on a leave of absence for 8 months without pay while it was trying to decide if they could reasonably accommodate her. So we're really fighting for that client. In a retaliation claim, all the employee needs to have is a reasonable belief that what they have suffered is, let's say, sex discrimination, race, disability discrimination. It could even be discrimination based on taking family medical leave, pregnancy leave, for getting pregnant, for being a woman. As long as there's a legitimate belief, something reasonable, that you really believe it to be true, you could have a very strong retaliation claim, but not have a strong, let's say, sex discrimination claim on its own. Sometimes the retaliation claims are really the stronger piece of the puzzle.